Great. My name is David Merland. My website is takefromcaesar.us. There's a link on the website to my YouTube channel where I have several lessons. One of the lessons already posted is called Citizens Oversight Commission or Citizens Review Panel. This presentation will be an expansion of what you see there on the web about the Citizens Review Panel. An extension, in part, some of it is a restatement of some of the content you'll see on the YouTube channel. We're in Seattle. It's September 10th. We figured we better get this out of the way before September 11th because the building might not be here tomorrow. Who knows? On the tables, you'll see a packet that looks like this. This is a printout of the felony and gross misdemeanor statutes, in my experience, are most commonly violated by police and other public servants and officials, and we'll get to those eventually. I want to speak on the idea of Citizens Oversight Commission, public review panel, whatever you want to call it. There are no laws governing a citizens review panel. Since it's our idea, it's not an idea that the state legislature, the city or county council came up with, and so we're totally open with what we want to do with the panel. Nobody can stop us until we do something illegal. And when I say we, anybody that feels they should set up a citizens review panel, I'm definitely one of those people, because our prosecutors and our courts let us down so often. There are certain instances where the police have abused women in their custody, and you see what does and does not happen to those police officers. And I have certain instances that come to the top. I'm not going to catalog and log into my memory all of the instances I hear of, but Michael Idland was a Washington State patrolman who was essentially, I didn't read in the FBI affidavits from the victims that he had actually raped the women he pulled over, but he was patrolling the east side and Highway 520, which is a floating bridge across Lake Washington, and women that he thought were attractive who left cocktail lounges, he'd follow them and pull them over in contrived drunk driving stops. And during the search, he would put his hand under their clothing, take them to jail, and do the same thing over again. Spent 16 months in King County Jail and was allowed to plead out to a gross misdemeanor, custodial interference, so that he wouldn't have to report as a sex offender thereafter, when what he did was bona fide felony sexual assault. And that was Judge Palmer Robinson that let him plead out to a gross misdemeanor. It was a prosecutor in Seattle that thought that was a decent plea deal. And that shows right there that you simply can't trust the system to do everything we expect them to do for us, while they're willing to say to get paid. So there's your proof that the system all too commonly lets us down. There's many other instances, like I say, I don't log them so I can cite all of them to you, but for the 16 months that Michael Idland was in jail, he drew administrative pay. And I cannot, as I stated in the last presentation, I cannot for the life of me imagine how the women of Washington feel knowing that police can do that and be essentially slapped on the wrist compared to what they should have had to suffer as punishment for that scope of crime. Like I said, I read 7 affidavits from the FBI that witnesses had submitted for the federal investigation of Michael Idland's conduct, and that the prosecution and the courts totally failed us. And so what else can we do? We have our vote. I know more about the law than to let my vote constitute the sum of my political power. I have more political power than just my vote. I'm not going to relegate myself to the status of serf, which is the masses. All they have is their vote. Look where we're at right now. We have to wait 2 more years until the Marxist in the White House is replaced, when in fact I can prove he's a felon many times over. What can we do? We can't do anything because we don't know anything, and so we have only our vote. While I'm over here with my knowledge of the law that says I can file criminal complaints to make it really politically tough for him to raise his head, if I could get some publicity, some support. I have the right to arrest a felon. And if 10 million people knew this and studied the conduct of this president leading up to his inauguration and thereafter, they'd see that he said to America everything he had to say to get elected, and it was 99% lie. The 1% that was truthful, 5 days before the election, we are 5 days away from totally transforming America.
Yep.
What about America makes it, in your mind, something we have to totally transform? Who are you to say that 310, 317 million people should totally transform their country? Who are you? You're from Chicago. You're a community organizer. You're not a founding father. You're not a Supreme Court justice. And you're going to totally transform our country for us? Michelle, the president's wife in Puerto Rico, 2007, before the election, is in a, as best I can recall, I don't think it was a hall, I think it was a big outdoor tent in Puerto Rico. She's speaking to a group, she's at a podium, and she says, think about the children and what they face. We need a better world for the children. You're going to have to change your conversation, change your traditions, change your history, and move to a different place as a nation. That's the single most heinous, abrasive, and offensive thing I've ever heard somebody in public life say. You're going to have to change your conversation. Who are you to tell me that? Chicago is the heart of corruption. You're going to have to change your history. Excuse me, you can't do that without lying to the children. You're going to have to change your traditions. In exchange for what? I'd really like to hear that. What do you suggest we change? What are our traditions first that you feel we need to change them? What is so bad about our traditions that you think they should be changed? And what are you going to replace them with? Now we know they have no plan. All they know is destruction of what we've got. And so, and it's symptomatic. It's the entire system that feels that way. Everything we have, they're trying to take. You don't hear widespread media coverage of somebody that used a gun to protect themselves successfully from a home invasion robbery. But if someone accidentally shoots somebody else, the media is abuzz with it. We need more gun control, and they pass more bills to legislate and cut down the number of bullets you can have in a clip. So at every turn, government is against the exercise of rights. The right to arrest a felon is a common law right. If you say under state law, RCW 9A16020, and we'll get to it in the list, that I'm going to arrest a felon even if it's a cop. They'll go, is that a threat? Well, if two people say that, if the cop and his boss, of two cops, or the cop and the prosecutor, or the prosecutor and the judge say threat, when all you did was say arrest a felon, how is that not a conspiracy against your common law right of citizen's arrest? If two or more persons conspire to threaten, injure, or oppress somebody else in the exercise of a right secured to them by the laws of the United States or the Constitution, conspiracy to deprive somebody of rights, 10 years, 18 U.S.C. 241, 10-year felony. So if they say threat, they've just committed a felony. That's how strong our rights are, is that once you know the criminal statutes, it's easy to see crime all around you. And I had a guy that was very well briefed and informed about everything that the quote-unquote movement argues. And he had gone to court for years and years watching clients of these people with organizations and websites and what they teach, and they teach somebody in his area, and he'd go to court the day they're supposed to appear in court and watch them go down in flames. He'd go to the symposium they have in California every year and rub elbows with these teachers and gurus, and they all knew him on a first-name basis, and they'd talk at these symposiums together. And so he knew all of them, he knew what they teach, and he told me after studying my courses for several months that, you know, I used to go to court and I'd go to court and I'd go to court, and I couldn't really tell what was happening around me. And now that I've taken these courses from Dave on criminal statutes, criminal code, criminal procedure, I go to court and I see crime all around me with all these violations. I can say they're committing this crime, that crime, this crime. And he happens to be a guy that tuned into my conference calls probably 2005, 2006 it would have been. And he thought that I was the biggest egomaniac. The system does not work like this. Nobody can do what Dave says he can do. The system's not made to work like this. Nobody can impress a judge with the law. Nobody can go up against a prosecutor. Nobody can. And he kept listening and listening and going to the web and the law library to verify everything I had to say. And then it struck him that everything Dave says I can find in statute, court rules, and the Constitution and case law. Everything he says. And then asked if he could be my promoter. So there's somebody that was a total skeptic and knew what everybody else does and had seen him fail for years, and then he sees what I do and he wants to be my promoter. And now he's doing great work in foreclosures down in California all on his own. Now, since the system won't do what it's supposed to, I feel, as an American, part of our civic duty, we should explore what we're able to do to take up some of that slack. So I work real hard on identifying when crimes have been committed by public servants. Because if I can prove a felony's been committed, I have every right to arrest that public servant. On my YouTube channel that you can link to from the homepage or take from Caesar.us, there's several lessons there. One is Citizens Arrest. One is Citizens Review Panel or Oversight Commission. There's a couple about the Internal Revenue Code. And I just posted one this morning about public vehicular travel. And with those arguments, I can prove every IRS agent and their bosses are felons. Because to tax the value of labor as profit, income, or gross income, you have to deprive me of the provisions of Section 83 of the tax code. And if you're scheming to deprive me of a statute to get my money, I feel that's a conspiracy against my rights. Very simple concept. 10-year felony. Plus, they're doing it in a pattern, racketeering and extortion. More felonies. They're doing it through the mail fraud, 18 U.S.C. 1341. That's 20 years in prison, max. So that's a big-time felony. You have some felonies that are 30 years, some felonies that are 20, 10, 5, so forth. Public vehicular travel. It's in the law from coast to coast. Highways are open as a matter of right to public vehicular travel. They're out there on the highway pulling me over when I'm exercising a right. That's unlawful imprisonment. Washington State Code 9A.40.040. It might be 9A.04.040. I think it's 40.040, unlawful imprisonment, Class C felony. Federal law, they're conspiring against my rights. They pulled me over when they knew I wasn't engaged in the privilege of operating a motor vehicle. Our second-degree auto theft statute says if anybody takes without permission any automobile or motor vehicle or willfully rides in an automobile or motor vehicle that's been stolen, and in one paragraph, 3 times they say automobile or motor vehicle. That statute was amended to read like that in 2003, so it's nothing old or ancient. And the motor vehicle doesn't mention automobile, when we know they're 2 different things. And there's a bunch more authorities I have in support of my claim that public vehicular travel is a common law right distinguished in legislation from the exercise of a motor vehicle, operation of a motor vehicle upon the highways of the state. So from that, I deduce, what you deduce is your business, I deduce that they're conspiring to deprive me of my rights when they forget all about the common right of public vehicular travel to enforce a privilege code on me when I'm not engaged in a privilege. So every traffic cop, every prosecutor of the major motor vehicle crimes like driving while poor and any criminal traffic violations, the prosecutors, and this would include private prosecutors. Some of the cities and counties, or cities anyway, contract with private law firms to prosecute criminal motor vehicle violations in the city. And then you've got the traffic court judges, the district attorney for the county, superior court judges when they're prosecuting felonies brought under the motor vehicle code. Those, of course, go to county superior court. I can prove all those people, as well as the director of revenue, the Department of Licensing director, and the governor. They're all felons. They're all in charge of this enforcement of the motor vehicle code against public vehicular travelers. On takefromcaesar.us, go to the public vehicular travel page, and there will be a link that says Google. Click on that. It's an automatic Google search for open as a matter of right to public vehicular travel. Earlier this week, I got 5.9 million hits. It's in the law from coast to coast. Go to my YouTube channel. I just put it up this morning on public vehicular travel. There's a course, an hour, 19 minutes, and it takes you through all the authorities that are in my memorandum on public vehicular travel. So for starters, if I were to set up a Citizens Oversight Commission, I have already identified systemic felonious misconduct, where with my first stroke of the pen, me and the other people on the panel who believe as I do, they look at this conduct and say, that's felonious, I'm willing to sign a sworn statement to the effect that I believe that's felonious, and call that an extraordinary writ of probable cause. This is to say that the panel is of the opinion that probable cause exists to make the citizen's arrest of everybody involved in the misenforcement of the motor vehicle code. Another extraordinary writ. We, the panel, after considering these provisions of the Internal Revenue Code, we are of the consensus, and this is a sworn statement, that everybody that's misenforcing the Internal Revenue Code upon people who merely sold their labor for its value are in felonious misenforcement of the law and are subject to citizen's arrest. You can't count how many public servants I just roped into my right and the right of every American to make a citizen's arrest of everybody involved. What did that just do for us? You have them, they're out here, they're coming at us. You can meet them and keep this space between you and them with the knowledge that this person, this citizen that I'm going after for taxes or for motor vehicle code, they know all about me. They know I'm a felon. I've looked at their memorandums. I can't disprove it. My boss doesn't have a memorandum to contradict them. And they aren't very pleased with the fact that I've been a felon for decades, my coworkers, my bosses, and so I better walk more softly. When the public servant walks more softly, You've just gotten more rights. Secondly, when they don't cite you, that's one less ticket through traffic court. That's fewer dollars into the coffers that are being used to acquire military weapons from the Pentagon for our local police force, for facial recognition software, for a Stingray cell phone interceptor antenna and unit. They can sit and intercept any cell phone conversation within a few hundred feet with a Stingray, that's the name of the device, in their van, and they just follow you around. They can listen to all your cell phone conversations. So we know where the money's going, and none of it's good. They took Social Security and spent it. Didn't spend a dime of it on seniors' retirement, education, the homeless, health benefits. Now they just upped everybody's premiums with the health care bill instead of funding it like Social Security was supposed to. So it's going nowhere, and until we take back some of our rights or assert rights they really weren't even aware we had, because they don't study what rights we have. They study their own authority. It's up to us to study our rights. And on YouTube, on my channel, you'll see a lesson on citizens arrest, where I go from coast to coast, circuit by circuit, with a quote from every citizens arrest court case I found in the LexisNexis database of federal cases. Now, I'm going to set up a panel. My first concern is staffing. Who am I going to have on staff? Well, since I'm going to be accepting testimony and evidence from individuals who feel they've been victimized by public servants or otherwise, it doesn't matter. They come to the panel and they say, XYZ happened to me, can you help me? My job as a member of the panel, as a member of the group, I don't have to be sitting on the panel, because the panel has more than just the people that hear the evidence. Our jobs as staff members is to hear the evidence and to sift the evidence through the language of these criminal statutes in our handout today and see which felonies have likely been committed. And our staff has to be able to do that. So on the staff, I want to have certified paralegals. That would be great. And we're climbing up a list of preferred up here, down here at the lower end. I at least want to have a certified paralegal on the panel. They already know the basics of legal research. I want to have perhaps a legal secretary from a criminal defense attorney's office, somebody trained in legal writing, and somebody who has seen court procedures go by through this lawyer's office. When the lawyer says the mundane delegation of responsibilities, I need a motion to continue, drafted for this case and that case. I need a motion for summary judgment drafted for that other case. I'll fill in the facts, or do your best with the facts, and I'll amend the motion you give me. So she goes, he goes, whatever. The legal secretary goes to work and drafts these little things so the attorney can concentrate on the big things. So they've already seen criminal procedure. They know how to write legal pleadings maybe, and up the list you go. You finally get to maybe a second or third year law student from Seattle University, maybe the University of Washington. Track down law schools in your state and see if you can't get criminal defense lawyer students, or students that want to be a prosecutor, to join your panel, because we're going to be weighing criminal evidence, evidence of crime, and here they are learning from a professor about how to do that. That's invaluable. The professor is supposed to prepare them for the work they're going to do when they go out there and get a job, which is the same work the panel's doing. And if you can get an actual licensed attorney interested in your panel to sit on the panel and keep you on the straight and narrow, that would be great. So my staff is very important. the people on the staff that aren't as learned. Shut your mouths and open your minds and your ears and listen to the people on the panel that know more than you. That'll keep you in the box. They'll only tell you what is necessary for you to know, and they won't fill your head with a whole bunch of Patriot Movement nonsense and tangents that have nothing to do with determining whether or not the accused has committed a crime. So your education, your learning curve, you're going to have a list of probably 10 or 15 state statutes, 10 federal statutes. You need to know those statutes and become fluent in the language and understand what somebody has to do to offend those statutes. Because you're going to have people coming to the panel with facts, and you need to be able to say, you know, considering those facts, I'm pretty sure this person has committed mail fraud against you. They know you didn't get a hearing, or they know you don't owe the money, and yet through the mail they're billing you. A great instance of that, in my opinion, would be a bank that has taken your promissory note on your mortgage and bundled it and sold it to another entity as a mortgage-backed security. Well, now that it's a mortgage-backed security, it's not a promissory note anymore. How can it be enforceable as a promissory note? And yet they'll go to court, foreclosure, and take your property away as if it's still a promissory note. And they'll bill you for it. They'll use the mail to mail pleadings to you and get you into court to take your property when it's still yours. Or a lot of other circumstances that banks are operating within to take people's property that are overtly criminal. And if they use the mail, 20 years in prison, 18 U.S.C. 1341. So you see how I looked at the facts of the case. I found a criminal statute that sounds like it really describes what the bank was doing. A plus B equals C. C is for citizen's arrest, because that's a felony. So as you meet more and more people that are actually in the industry and not outside with gold fringe flag, maritime, administrative, and the rest of it, set all that aside. This is way more simple than that. And as you build your staff, I personally wouldn't try to hear a case until I had about a dozen people working with and on the panel. I want 6 panel members at least, and then we'll have out here. And the panel members, it might rotate in and out of this satellite position of barrister. When somebody is accusing another of criminal misconduct, thank you for coming to the panel. We need you to write down an affidavit for more about what we require. This is our barrister. He'll help you prepare your case, and he'll present it, she'll present it, whoever the barrister is, present it to the panel. And so get with them, tell them everything, and they'll develop the documentary evidence that the panel needs from you, and they'll present your case to the panel. They'll swear you in under oath if you're going to testify at the hearing, which is likely. And when the barrister says, we're moving forward with this, I think a crime has been committed, they'll serve the complaint with the evidence on the panel. I'm on the panel, we get together, and we say, you know, this looks likely. And so we sign the notice that the barrister has prepared to the accused. And we put all of that behind the notice, and we send it to the accused, whether it's a cop or a neighbor that stole your stereo, or smashed the window in your car, or a cop that falsely arrested you, or the mayor that did ABC, whatever. We send the notice and the complaint that the barrister wants us to sign, saying this is the crimes you committed, with the evidence. We send that to them and say, on a certain day, there's going to be a hearing. You've been accused of these crimes in the complaint. At this point, you're hereby notified we're inclined to endorse at least one of these requests of the crimes alleged in the complaint. And you're welcome to come and present evidence to the contrary, which includes testimony. If you come, we'll swear you in, and we promise that the right of citizen's arrest will be suspended for the purposes of the hearing. So if you're guilty, don't fear being arrested when you're at the hearing. You'll be allowed off the premises. That way all the doors are open for them to come and present their side of the story if in fact they think they have evidence to the contrary. So your education, meet and study together. You have blogs that can be totally private. Nobody else can enter the blog. So form a group. Your panel members don't all have to live in the same area. Some of this can be done remotely on a conference call. When the hearing goes down, there can be a speakerphone right there, or Skype, whatever, microphone, so that people that maybe even live in another state that are on your panel have looked at the evidence, they got it from you in PDF format over email or whatever. And so they don't have to necessarily live nearby or be nearby when the hearing goes down. And through the mail, you can get their sworn statement notarized in their state that they attended the hearing via Skype, and I feel these crimes have been committed. I've looked at the complaint. Please add this sworn statement to the stack if the panel ultimately agrees, like I say. The email list, everything can be totally private. You don't have to publicize it. It doesn't have to be a website. And so if you can't meet physically in one place, you can still correspond. You can still get a webinar service so you can all meet and actually see each other while you discuss a particular case. So don't feel this is going to lead to a bunch of trips downtown or trips out to somebody's house rurally where they have a garage where you can all meet, or a rec room downstairs. It can be done online. So use access to the internet in your favor to streamline your process.
That's great.
So you're going to learn the essential elements of every statute. To be guilty of this violation, they have to do A, B, and C. And if they did B and C but not A, then they're not guilty. And you move on to another statute. Once you become more and more familiar with the most common of violated statutes, you'll be able to sift those facts through the criteria very quickly. If I see action on the part of a public servant and I know that a certain element is lacking, I know that I don't suspect them at all of a violation of this crime over here, but maybe this one. It might not always be mail fraud, but it might be official misconduct. So familiarize yourself with the 10, 15, or 20 most likely offended statutes. Legal writing skills. Learn to type. I didn't get any respect from government until I started writing and filing citizens' criminal complaints. You can't write and file citizens' criminal complaints until you can type. Sorry. And so don't be afraid of the computer. Computers are way better than typewriters. Word processors are better than typewriters, but they're nowhere close to computers. Get a computer. They're very inexpensive these days, for even real nice ones. And get fluent in Microsoft Word 1997 through 2003. Because Bill Gates wasn't doing all of your thinking for you until after the 2003 version of Microsoft Word. Before that, I stripped down the Microsoft Word program. There's a lot of things it'll do for you automatically if you want it to. I strip it down to where it's this close to being a typewriter so that I'm in charge of everything. Margins, spacing, font size, color, everything I do myself, because all I'm going to do is legal writing. I don't need 5 different templates and formats and font colors. I don't need to know more of them. Times New Roman and Courier. So I don't need the other 500 fonts that you can get. So I use Microsoft Word in a very basic way, and so I like the 2003 and older versions of Microsoft Word. If it says affidavit.docx, that's the new version of Word. I open up if somebody sends me a docx document, I open it up and then I save it in the old version of Word, which is .doc, and I kill or delete the version that's docx, so it's not even on my computer. Because as soon as you try to work in docx, it's got a million things you got to get out of the way because people at Microsoft think they ought to do your writing for you. Legal pleading is a lot easier than that. It's word processor or typewriter function done on a computer. Don't let the computer do your writing for you or make your decisions for you. The panel's going to have to keep records. I should write a couple of these down. Education. Learn from others on the panel that know more than you. Essential elements. What is and is not a crime. Based on these facts, we find you didn't commit mail fraud, or you might have. You didn't commit official misconduct because the act wasn't done in an official capacity, whatever. You'll look at the essential elements of the criminal statute, look at the facts, and say they don't quite meet this description, or they do meet it. Legal writing. And the panel will have to keep records. This is important because the people you're up against typically will be government, and you want to know you have records of everything you do. But you also want them to know we got records of everything we do, such as a disclaimer. Nothing you're going to hear is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. That's the disclaimer I use in my videos and in my courses, so that nobody takes anything I say as legal advice. Today's no exception. But when the government looks at your panel, you want to make sure that the government sees you're not giving legal advice, number one. Number two, we're not issuing indictments. That's what the county grand juries are doing. We are not issuing arrest warrants. It's not our fault that common law gives us and assures to us the right to arrest a felon with any necessary force. In fact, there might even be state statutes out there that authorize the arrest for a misdemeanor. In the list of citizens arrest cases you'll see on YouTube in the citizens arrest compilation, there's a case about an Arizona statute that allows for the arrest of one reasonably suspected of having committed shoplifting, which is a misdemeanor. And they said, since this derogates from the common law by allowing a mere misdemeanor arrest, we have to construe it strictly and let it apply only to this misdemeanor of shoplifting. It doesn't apply to all misdemeanors. But the felony citizen's arrest right applies to all felonies. I want a record so that I can say to any accused that missed their hearing, you were notified at this address. We sent you the notice that the hearing was going to take place. And so, no, we're not having a hearing where you can present evidence. You're welcome to present it in writing, but we're not having another hearing on it. I have records that the accused is on record with the panel. We were just going by what the accused said under oath in that sworn statement. There. Now the panel is not culpable for lies that may have led to the arrest or termination of a public servant that was falsely accused by somebody that came before the panel. At least the panel took the caution, or was cautious enough to get a written sworn statement from the accuser. So you're going to have all the records intact permanently. If anything is scanned into PDF, which ultimately you'll have to do, storing legal pleadings and files and all that stuff can get very cumbersome, you might reduce it to PDF or not OCR, but PDF format, and then store it on multiple hard drives. So if one is seized, you still got a copy. If one gets burned up in a house fire, if one gets fried in some type of electrical failure in a certain building with the computer that it's hooked up to, at least you got a copy. So you want to keep your records safe, keep records to begin with, and let the government know that we're recording everything we do. If you see anything wrong, We could use all the legal advice you'll give us. If if it looks like we might be headed toward a violation of the law, we welcome your comments and suggestions, because this is all we're doing. We're not doing indictments, arrest warrants. All we're doing is issuing opinions as to whether or not a crime has been committed, and if it's a felony, we're issuing an opinion to the effect that we believe this person is now subject to citizen's arrest for the duration of the statute of limitation on the crime that was committed. If it's a felony in Washington State committed by a public servant, statute of limitations is 10 years. That's fantastic. Video recording of your hearings. Videotape all of your hearings. My camera is not a professional grade camera. It does just fine. You don't see me with an extension mic closer to me. It's 12 feet away, and I know the audio is plenty sensitive enough for a satisfactory recording of this presentation. Don has a professional grade camera here today, and he has a microphone nice and close to me. Whatever you have to do to operate a professional camera, whatever you have access to, just make sure it's adequate to record your hearing on the criminal complaint. Website and website management. You're going to need somebody that knows how to set up a website, how to maintain it, how to upload files, how to work with the video files that you shoot, how to edit those to where you don't have a big space at the end or a big space at the beginning of non-action with the panel. You don't want footage on the web of a bunch of people saying, well, should we start now? No, so-and-so's not here yet, and they got chair number 5 on the panel, and you don't want to videotape a bunch of people waiting around. So whoever's managing your website has to be able to edit your video files down to where as soon as the gavel drops, the video starts. They have to be able to take your documents and scan them into PDF format and then put those on the web and make the links to those documents on the page that represents the proceedings for that particular hearing, that particular criminal complaint. So website management, that's your webmaster. You're going to need to be able to pay for the website and the webmaster. Keep them entertained. You don't want somebody that's doing it for free unless they've already proven they can really do a great job on it and they're willing to do it for free. I'd rather have somebody liable to me under contract because they've been paid as a webmaster to manage the documents. They might tell you, well, first, if I'm going to do all this, I don't want to have to be the one to scan the documents into PDF format. You have to do that. I want them in this resolution, 300 by 300, and I want each of the exhibits separately. And I want the name of the file in a Microsoft Word list of file names so I know what links I'm making when they go into certain folders and I upload them to the web. Also, they're going to manage your YouTube channel. So I will give my videos, I'm on the panel, and I give my videos to my webmaster so he can put a beginning, an intro card, like it might have the date and the name of my commission, if I have a name for my commission, and an ending on it, and then he'll produce a final video on his video editing software and then upload it to the YouTube channel. So that if somebody wants, they can go and chronologically look from day 1 of your YouTube channel and look at your first hearing, your second hearing, third, fourth, fifth, sixth, and just climb the list of your hearings until they're looking at the most recent hearing that you've held with the video tape or recording that was made of the hearing right there on YouTube. And we're going to be saying the name of the public servant that's accused. I feel that we ought to try to pay the overhead of the panel with the money, the contributions from the people that make the accusations. The panel's going to have overhead and expenses. If you want to try to rent a room, it's perfectly your prerogative. Do so in a quiet place. You might have to, this room is a room in a local Seattle library. So you have rooms in libraries. I don't know what it's like out in rural America, but plenty of cities have many libraries. Get the feel for when they rent it's not rent, these are free rooms, but for booking rooms, put your thumb on the pulse and see what it takes to get consistently booked in free rooms like this. That's a way to eliminate some of the overhead. But you're going to have copy costs, your copier needs toner, you're going to have to buy paper for all the documents and exhibits that you have to send to the accused. The panel members are going to want a copy of at least some of it in front of them when you have the hearing on video. Then there's credibility. Don't allow, and this is me, what you do is your business, because there is no hard, fast rule on how to conduct yourself as a panel. I'm simply giving you the most basic elements I feel have to be considered to operate a panel. But if you're a Citizens Review Commission or a Citizens Oversight Commission or Review Panel that is going to consider gold fringe flags, CAFR reports, maritime, administrative, admiralty, all capital letters, limited scope of Washington, D.C., and I'm a non-resident alien to that citizenship. Any of that, and I'm out. I don't want anything to do with your panel. I've got a bunch of indictments in a folder on my computer desktop of people that are going to prison because they followed Patriot Movement morons that have websites and curriculums and a prescription saying, do this, do that, file this form, you get all your money back, claim to be this citizen, whatever. And these people are going to prison. I have nothing to do with anything concerning the law that's taught by anybody in the movement. It's a movement, it's a fraternity, it's not a movement, it doesn't move. I've been watching it since 1990, and it doesn't move. I won't have anything to do with it. If you're a Citizens Review Panel that solely sits to observe the facts, compare them to criminal statutes, and offer sworn opinions as to whether or not a crime has been committed, your function is to take the emotionally charged victim of the crime out of the loop and settle down and say, we're not the victim here, and so the government or the perp can't blame the emotions of the victim. Oh, you're just upset because of A, B, and C. Well, no, we're not upset. We're the panel. We aren't even the victim, and we've considered the facts without the clouded mind and emotions of the victim. And this is what we've done. We've looked at the facts. We notified you. You didn't show up at the hearing, so we went on the facts submitted to us, and we think you're a criminal. If you're doing more than that with your panel, if you're issuing process that says this is an indictment, this is an arrest warrant, I don't want anything to do with you. Because you have no credibility and you're going to sink me with you. You don't know your foe. Any prosecutor for the government, it's their job to point a fire hose full of lies right at the judge and fill the record with so many lies you could never refute them because the judge will never give you the time to do so. That's an American prosecutor. It's easy to be better than those people. And if you're not dead set on being better than our prosecutors and forgetting everything you think you know up to this point, unless it's arguing in the box, I don't want anything to do with you because you'll sink me. I'm going to have my credibility, earn higher credibility, and I'm going to keep it. I'm going to stay in the box with the prosecutors and use just the tools that they use, but I'm going to tell the truth, which sets me apart from them, elevates me above them. So keep your credibility, no movement. You keep your credibility by emphasizing your education. When you have perhaps a law library on your website, the panel's website, go to our website and we've got a list, we've got a PDF, at least a link to the cases that you've read on the web, or a link to the PDF copy of the cases that you've read and you base your assertions on as to whether or not the essential elements have been met, whether or not somebody's innocent, and keep a log of all the cases that you study. to determine, to accomplish the elements of your role as the review panel. I'm going to do some more writing here, catch up to myself. So I'm going to keep records and video and web management and overhead, paying the expenses. That's a $sign there. And I can keep my credibility by my education and my knowledge of essential elements of the pertinent statutes and staying right there in that box, totally enclosed. If somebody wants to know what we do, all they have to do is look inside the box. There we are. And there isn't a single bit of what we do that's outside the box. Really, to me, it is so foolish to reach outside the box for anything, because while remaining utterly inside the box with everything I do, targets are everywhere. I could spend all of my money and all of my time writing criminal complaints, because I'd never run out of, there's one, there's one, there's one, there's one. They're everywhere. And then when you can truly prove with statute that everything the IRS is doing is criminal, mail fraud, extortion, racketeering, conspiracy against rights, those are the high points. Everything they do violates those statutes. Suddenly, every American can arrest everybody involved in the enforcement of the Internal Revenue Code against Americans. Neat. When you can do the same with the Motor Vehicle Code for public vehicular travelers. I'm not talking about taxi cabs, dump trucks, Greyhound bus line. I'm talking about, I went to the store, I went to my friend's house for dinner, I took my child to the soccer game. That's public vehicular travel. If you're not for hire, the Motor Vehicle Code does not apply to your conduct. So when I can put that many people under that umbrella of citizens arrest for having committed felonies, why would I have to reach outside the box? I'm not doing my job. I'm not looking closely enough, or I'd find plenty of things inside the box to occupy my time. Like I said, every penny I bring in could be spent on paper and ink, and all my time spent at the computer if I were to report every crime I know of. The media, very important on this list. The first thing I do, and this is me, how you run your panel is your business, the media. The first thing I do is I create a distance between me and the media. They are not my friend. Their position in society is to lie on behalf of the government as much as it has to make government look great, no matter what government does. Hey, over there in Iraq, the depleted uranium ammunition that the government's using is killing tens of thousands of Iraqi babies in the womb with radiation poisoning. What do you think of that? And the media puts some spin on it that I'm afraid to even consider what would come out of their mouth to justify it, but they will. And so I don't want anything to do with them, except to tell them, this is what I do. It's the exercise of my common law right of citizen's arrest. It's not a threat. And if you team up with the government to call it a threat, when you know, here's our brief on citizen's arrest, you are engaged in a conspiracy against my rights. That's a felony. And so, stay out of it. You're not a cop with pepper spray and an M16 and a patrol car. You're a reporter with a camera. And if you come out against us by teaming up with the government to call this a threat, you're a lot closer to being arrested than a cop is that commits a felony. You're just a private citizen out here. Don't make us line up in front of your building with a bunch of picket signs and a bunch of people open carry waiting for you to get off work so we can arrest you. Don't do it. And so you will stick to the script. We are not the sovereign citizen movement. We are not this. We are not that. We are simply citizens that are angry about the fact that the prosecutors and the courts let us down, and that there are systemic modes of enforcement that are patently felonious, and you won't do anything about it, and you can't deny you have no education in law whatsoever. And so you leave this up to the Americans and you shut your mouth until you're ready to report, this is all we do. You're going to report what we do, and you're not going to have any conjecture, you're not going to make any snide comments about what you think we're doing, or we have to consider that you've just entered the conspiracy to deprive us, threaten, injure, or oppress us in the enjoyment of our right to arrest a felon. That's a felony, and you'll be arrested if you're not careful. Now that we know where each other stand, let's be friends. First.
Well, I was going to say that today is a perfect day for talking about the media on the eve of the anniversary, 13th anniversary of 9/11.
Yeah.
I mean, it's so blatant now.
So first, I'm going to tell the media where they are and where they have to stay. Now that you know what your limitations are, and now that we know you're going to honor them, we'll tell you in advance of all the hearings that we're going to have. We'll post copies online that nobody else can see before the hearing, so you know what hearing we're having. And we'll give you an inside track as to which public servant has been complained of, who we're going to hear a complaint about, and if you choose to come with a camera, you're welcome. And if you don't come with it, doesn't matter. But these are the rules if you choose to do so. And so let them in on it after you put them in their place. This is part I didn't want to come to, but it's a necessary part. The prosecutor. I haven't done this particular Google search, but if you did a Google search for disbarment, failure to prosecute, you will find case law that says a prosecutor can be disbarred for failing to prosecute. So when the panel has a complete complaint, affidavits, exhibits, before or after the complaint is heard and adjudicated by the panel, it doesn't matter. Send it to the prosecutor. Personally, I would wait until afterward, when I know that the PERT can't even show up at the hearing and contradict the evidence with evidence to the contrary. That way, I'm giving the prosecutor everything he needs to know, plus the panel's sworn opinion that, yeah, this constitutes crime. Then you give it to the prosecutor, serve it on him. I'm not saying put it in gift wrap with a bow on it. Okay, I take 2 copies. One is for the panel, and I go up to the prosecutor's desk downtown at the county building, county administration, and say, this is your copy. Can you please stamp my copy received? And there, now the panel has proof. The prosecutor knows all about this crime. I'm climbing the ladder. It's one thing to get the cop in trouble. It's another thing altogether to get the prosecutor in trouble. Political animal. Now that I have a certificate of service or a date stamp received for my complaint, it goes on the web. So everybody that sees my YouTube channel and my website knows that the prosecutor's been served with this. And then we all sit back and just watch. And that prosecutor's going to do nothing. Well, now that you've chosen to do nothing and you have all the evidence, you were invited, you were asked for evidence to the contrary. How are we mistaken? And you can't even talk to us about it? We think you're the one in dereliction of duty now. You've got evidence of a crime, you refuse to prosecute because they're a public servant. Now we're putting a page on our website about you. He's not a conspirator against my rights, he's just a derelict. If he fails to prosecute, look at official misconduct. If a public servant engages in unauthorized conduct or fails to perform a duty imposed upon them by law, to deprive somebody of a right or privilege. He's not depriving me of a right or privilege, so it's not official misconduct. But it's a dereliction of duty. And I think in the back of our key criminal statutes, There's a statute that says if a public servant, if it's not punishable somewhere else in law, and a public servant fails to perform a duty imposed upon them by law, it's a gross misdemeanor. So, the prosecutor, first, I put them in their place. Just like I did with the media, saying, we do not issue arrest warrants or indictments, we are not this group, we are not that group. The only thing we do is hear evidence and issue considered opinions, because we have educated ourselves on essential elements, and we have people on the panel that have certifications that we believe a crime has been committed. That's all we're doing. If it's a felony, we know that since this is our reasonable suspicion, we've acquired the right to arrest this person, as has 317 million Americans, and that's all we're doing. It's the limit of what we're doing. We're not doing anything more than that. And I'd educate the prosecutor on what we're doing. Number two, now let's be friends. We're going to give you finished complaints and sworn statements from the panel that have everything in them to show you the basis for our complaint against this accused person, this criminal. And if you don't prosecute, we're going to make it political on you, and you won't last another term. How long was Norm Mailing Seattle attorney? Long time.
Yeah,
too long. Somebody bigger than all of us felt the same way and struck him down at a lecture at the UW. He was lecturing, suffered a heart attack, and died. Yeah.
I can see that as a pivotal point. If you make everything available that you up front and give it to him non-prosecutor, I believe they call it, it's a Latin term for failure to prosecute. But you have all this evidence up front, and
right.
You always give him the notice, so he's got a chance to,
yeah,
I better,
yeah.
you know, play ball here.
So the only reason he can come up with is, it's a public servant, so I'm not going to prosecute him. Okay?
Oh yeah, that's what I'm saying. Then
so,
you got him on the
so there's two compartments for the prosecutor. The first one is educate them, put them in their place. That we are not this, 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 or this. If you say we are, we know you have just entered a conspiracy to deprive us of the rights we're exercising.
That's a crime in itself.
That you're infringing on our right to free speech by calling it a threat, and you're conspiring to deprive us of our right of common law citizen's arrest of a felon. And so, for as long, if you want to attack us, go for it. You can be arrested. But secondly, if you're on our side, prove it. When we give you all this proof that a crime has been committed, we expect to see a criminal complaint filed in Superior Court if it's a felony. We expect it, and we will have it, or your face is going to be on our website with an online petition that people can sign for a small contribution to the panel, and we'll take a bunch of copies of that, save them up, and every week we're going to send them to your superiors and publish them online. So first, educate, then make them your friend, and see if they can keep it that way.
Sure.
Next, the cops. Educate them, and that means the county sheriff, the police chief, because everybody below them is paid to not learn how to read. And so you don't want to do this to a cop at a traffic stop. At a traffic stop, you get out of the presence of the officer as fast as you can. Yes, sir, no, sir, you saw the window sticker, didn't you, sir? Okay, and you're going to issue the ticket anyway. You've seen our website, that's all I can do with you. Thank you for the ticket, have a nice day. And you get out of their presence. They have guns. And we know from the John T. Williams case, August 31st, 2010, the Native American man downtown Seattle sitting on a curb, whittling on a piece of wood with a 3-inch knife, confronted by a Seattle cop, dropped the knife. He stands there and goes, "What are you talking about? What are you doing?" And the cop shot him 4 times and killed him on the spot. They found that the shooting was unjustified. The cop was allowed to quit and move away. No charges. They could kill you as a freebie. And so, yes sir, no sir, you're too stupid to speak to, sir. I'll go to traffic court and arrest the judge because you issued the ticket. Thank you, have a nice day. And get out of the presence of the cop as fast as you can. But they have bosses that can read. They're required as part of their job to know at least some of those statutes. And so I would serve on the city police chiefs locally to you. There might be several small or big cities even, and the county sheriffs that educate them first. This is what we do. We do not do this, 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 or this. All we do, we issue opinions. We determine by the facts presented whether or not a crime has been committed. And we issue opinions without the emotional victim of the crime in consideration. We just take their facts and consider it without all the emotion that they have about the case, which gives our opinion more credibility. We are educated to a degree. We feel confident to look at these facts and make decisions, and we're going to be doing this, and you need to tell your officers, because they need to know if they cite us and in our window they see our emblem, maybe with a little eagle on top, okay, whatever. If one of these is in the rear window of our automobile, our panel's window sticker, trust me, if we get a traffic ticket, because you've just received a copy of our motor vehicle brief, our public vehicular travel brief, and if you cite us, you know it's us by our emblem in the rear view, the rear window of our car. If your cops cite us, we'll be in traffic court talking to your judge about a citizen's arrest for racketeering. They've been doing it for decades. They're going to be doing it tomorrow. They won't stop. We know it, but we know it's racketeering. And at the same time, educate the judges so that you have the cops at the bottom of the food chain. It's built on intellect, so we know the cops are at the bottom of that one. And at the top, you got the prosecutor, the judges, the county sheriff, the police chief, all going, what are we going to do? And the smartest one in the room goes, I'll tell you what you're going to do. You're going to ignore people with this in their window. First off, because otherwise we won't be able to keep a judge on the bench. It's a good thing. So educate the cops through their bosses and then make them friends. You're not going to cite me. I have this right of public vehicular travel, don't I? If they say no, well, I think it's time to arrest the judge and find it, try this out, issue that ticket. And it comes to the judge. What the judge says goes. The judge is going to give feedback. It goes down the line to the cops and the others saying, if they got that window sticker in there, you're asking for it. I don't need my name and my divorce record, my tax court record online with these people, so don't bring them into my court. Because that's right down the list here. I'm almost to that point. Now, the accused. Nobody likes to be falsely arrested, and that goes for a public servant that has not committed a crime. And so the panel is never to be used as a vendetta. If a public servant's doing their job, that's the government we want. We're not anti-government, we're anti-corruption. That's all. Very simple concept. Never let your panel be abused, lied to. The person that testifies or supplies a statement, they're sworn in under oath, saying everything in that statement's true. Believe it. Or let me testify. And they're sworn in under penalties of perjury before they testify, just so they know, excuse me, if you get somebody falsely arrested, you might have committed a felony by doing that, and you can be arrested yourself. So you don't come into our panel and feed us a line of BS. It isn't going to happen. So the accused has rights. Very important. We know what it's like as the accused to be falsely accused and suffer the ramifications. Some of us more than others. The victim, the complaining. The victim comes to the panel and they have basically a cause of action. The action is that the panel issues opinions. And so the accused has to be respected to that degree. The accused comes to the panel and they have an issue. The panel is there to help the accused. And so the panel proceeds on behalf of the accused. We have a barrister. The barrister cares about the accused. It's the reason they're serving. If they're just there so they can get in the process of getting criminal complaints filed against public servants, they're the wrong mentality for barrister. And as I stated, I think it would be a good idea to have the different people on the panel rotate through that position of barrister, to where for this hearing and the next hearing, you're the barrister. And so they get up off of the panel and they operate as in a satellite position, they're the barrister. The accused, okay, let me help you prepare your case, and your case I'm going to present to the panel. And the one that was the barrister gets to sit on the panel and rotate through so you can see both sides, what the panel has to consider and what the barrister has to do for the accused. The accused, I'm sorry, for the victim. The one who's making the accusations. Even if it's a big, rough guy that's been falsely arrested, they've still had their rights violated. So it doesn't matter. It can be somebody, it can be a woman that's very small and frail that got falsely arrested and was thrown into the can with a bunch of scum, right on up to the bouncer from a biker bar that's way out in the woods that got falsely arrested. Both of them have suffered the same ramifications. And so the barrister should know that you approach the victim with care and caution. You want everything they say to be accurate, and you want to get everything in writing to go on the website, and then you present the panel, the case to the panel with the objective of getting realistic charges signed by the panel. Create a public record. I think it should be standard operating procedure of the panel. We got a complaint against Lieutenant Anderson of the local police department, and then you take a standard FOIA request or a State Disclosure Act request that has oath of office, a copy of the ID that the department issues to them as a bona fide police officer. I want a copy of this, a copy of that, everything that they have to have on file. And then I'd send that in to the department. I want a copy of everything in their employment record, see how much of it you get. I want an abstract of when they were hired as a cadet out of school, as their first job was the department, and the chain of promotion. And then another person, I would want them to know how to look up tax court docket numbers, divorce court, IRS tax liens, bankruptcy numbers, civil and criminal court, state and fed, and get a dossier worked up about this accused officer. If they're found likely guilty by the panel, then I would put this personal information on the web. But if the panel doesn't feel they've committed a crime, let them go. We're not anti-government. We're anti-corruption. And if there's somebody that, you know, I think this guy's a criminal, well, he has no business near a school, no business near our neighborhood, no business driving around in a car designed to take people away against their will. Get him off the job. You got 30 days, chief, because after 30 days, this is a felony complaint. We've sent it to the prosecutor. And if we don't see action on this or a cogent rebuttal that dissuades us from our beliefs, and you don't take action within 30 days to get him off the force, we're going to arrest him and bring him to you. And if you don't do anything then, we're going to arrest him again and bring him to you. Because we have that right. So I want to create a public record to make it a bad idea to pull over somebody with this window sticker. Because it can only go nowhere. You can only pull them over if you misenforce the motor vehicle code against them. What were you thinking? You got the memorandum. You've listened to your boss. Your boss has listened to your judge and your prosecutor saying, don't do that. And you pull me over? You just put the pen back in your pants and we'll call it a day. Nice to meet you. You're free to go. I don't need you to tell me that, but thank you. Yeah.
When you start the dossier, that's only for the accused that comes to the panel. Do you
The person that's accused, I would investigate to that degree.
have that, or is that a requirement that he has to bring to the panel?
It's certainly not a requirement, but just because this is a political game we're playing,
Okay.
I would want politics to favor me and find them unfavorably. And so I would have everything I could dig up on this person and put it on the web saying, it's a bad deal for your crime to make it to our panel, because it comes with a lot more than just our statement saying we think you're a criminal.
Is that going to be withheld until the staff makes the decision on the dossier?
I think it should be. Don't disclose it all until you
Yeah.
have come to a conclusion that the guy's a
After the
criminal.
accused is about a panel, makes a decision, then the public record
Right.
is found on the web page.
Right.
That anybody can look at.
Right.
And understand his timeline and
Right.
dossier. Cool.
And that's how to exploit the public record. That was my next bullet point. Drag the superiors into the politics. The police chief, the prosecutor, the judge. It rolls uphill. Magic. And so you create this laundry at the bottom, and when they fail to act upon it to keep our government clean and forthright, it rolls uphill. And you bring the police chief and the sheriff into it, and you put it on the website. He knows about it. He won't get this cop off the job. The prosecutor knows about it. They won't prosecute this public servant, whatever. And so we need them out of office because they think we should answer to a bunch of felons, and they're wrong. So I drag superiors in. It's political. This whole stack is political. City and county council. I'm just going to put council down here. The mayor, I believe, as far as I've heard, in many instances, the mayor has the authority to terminate the police chief. And so if the police chief is not doing his job, complain to the mayor, the city council, go to the county council about the prosecutor, if it's a superior court prosecutor, or county prosecutor. I'm not straight on that, even if it's a uniform chain of command, state to state, county by county, find out who answers to whom. And in there somewhere is going to be the county council or city council, and you drag them into the politics as well. Don't forget the county council. Now, this is important, and it's right along the lines of council, so I'm going to indent it. 4.92 and 4.96. In 1974, the Washington State Legislature said, we find it undesirable that public servants are immune from suit, and so we hereby waive their immunity. You can sue them. But since that was a voluntary waiver on the part of the government, they could put a condition on it. And they put a condition on it saying if you're going to sue a public servant or a municipality, you have to first notify the municipality and wait 60 days. And if it isn't settled in those 60 days, then you can sue. 4.92 is about the state. You can sue the state, but you have to wait 60 days. 4.96, these are chapters of the RCW, Revised Code of Washington. Chapter 4.96 is about municipalities. And so if I'm going to file a tort suit, or if I'm simply going to make a big stink out of what happened up here and I didn't get any remedy, I'll file a claim for damages if it's a tort, like false arrest, with the council for the county, city, or maybe a state under 4.92, a state claim for damages if it was a state public servant that damaged me, like a state patrolman maybe. This is not politics, it's money. Hit them in the wallet. Sometimes that's the only way you'll get them to open their eyes to you. And so I hit them in the wallet with a claim for damages because I didn't get any remedy up here. They're all derelict, they won't prosecute, they won't fire the person, and I was falsely arrested, claim for damages. You might make this standard operating procedure, not even wait for non-performance. You might hit them in the wallet to get the county or city council to act on these people. Say, what are you doing? Get them off the force. We don't need a bunch of lawsuits, and this guy's headed nowhere. The public doesn't like him. Get him out of that patrol car, he can go to work, you know, up the freeway 30 miles, there's another city, they need a couple cops, we just don't want them here. Great. So by hitting the municipality or the state in the wallet, county or city council or the state, telling them that you're going to sue, it rolls uphill from there. And they start kicking people responsible for policing the ranks. Okay? Tort attorneys. The panel, keep your credibility, keep your education in progress. Learn and learn and learn. And in your area, put your finger to the wind and find the local attorneys that are willing to bring lawsuits against government. Attorneys already versed in suing for tort. And see if they want to, if you get a certain accuser, a victim, to come to the panel with their complaint, and you go, you've got a great lawsuit here. The county was out of line with what they did while you were in jail, or whatever. It would be nice to have local attorneys that are interested in suing government. Find out who the good ones are.
Who the hungry ones are.
Same thing.
Yeah.
And you find out the local attorneys that are on top of it, and if they want you to notify them if you come across a victim that really needs some help, and you're going to develop the evidence and the criminal complaints and everything, you've done all the political work for them. And so they just take what the panel did, and then they file the lawsuit, and they go meet with the people that they sued and say, do we really have to go through with this? Or are you going to settle with her? Because these are the questions I'm going to ask you at the deposition. Look at this criminal complaint. You got a copy of it. You kept the guy on the job. That means you really, it's pretty much policy with you people. Do I have to sue over this? You're going to settle with her. So the panel's process might contribute to success in a tort suit. You might familiarize yourself with the local attorneys that are willing to sue the government and are good at it, and approach them and say, this is what we want to do with our panel. Do you have some suggestions so that we run our process in a way that better prepares you if you were to help one of the victims sue ultimately? And there's another source of education, is the tort at the end. And the window sticker, a bumper sticker, it doesn't matter. Some way that when you're out and about, the traffic enforcement personnel see you and they know our boss was told by the judge to ignore this person. And so they just ignore you. That way you're not the victim of a felony. You don't have to go to traffic court and ask the judge, do we have to arrest you today or should we wait until tomorrow? Are you going to make it to work tomorrow or are you going to be arrested? So, the window sticker. And this is really the last thing on this list about the operation of the panel. And now I want to go quickly through this list. There's a few of them on the tables. It's a compilation of what I feel to be the most likely violated Washington state statutes. It starts with the statute of limitations on a felony committed by a public servant, and all of this is in the YouTube presentation you can see by linking from my homepage at takefromcaesar.us. And this is in the, I think it's in the Citizens Review Panel video. This compilation right here. It's a document right out of that video presentation. So if you want to know more than what I say here very briefly as we go through this, you can go to YouTube and find out the details. The first one, statute of limitations, 9A.04.080. That's Revised Code of Washington, RCW. The following offenses may be prosecuted at any time after their commission. Murder, homicide, okay, great. B, except as provided in subsection C, which is about minors, the following offenses shall not be prosecuted more than 10 years after their commission. Number one, any felony committed by a public officer if the commission is in connection with the duties of their office. 10-year statute of limitation on a public servant's felony. So if you identify a felony and you know you have the right of citizen's arrest, you know from this, it lasts for 10 years if it was a public servant that committed it on the job. Man, with what I've been through and what I've helped other people in and out of, and to see that I have a 10-year learning curve. The felony was committed against me yesterday. I have 10 years to learn everything I need to know to nail that person for felony and arrest them. I've got 10 years to start my education and get it to the point where I know that was a felony, and I then have acquired dominion over them. I have acquired dominion over them. I can go get them and take them to the FBI. So, for 10 years. Fascinating. Page 3. This is Dianatic reasoning. Dianatic is when you take one point and another point and another point, you add them all up together to make a bigger conclusion. And that's what I did. I layered things on top of one another, this and that, and you come to the top, I have rights. And suddenly you learn enough and you know that I could walk right up to this person when they're buying a head of lettuce at Safeway and push them up against the counter and cuff them and take them for what they did to me. The law is perfect. This is why the panel doesn't need to do all the other stuff you see people doing. We don't issue indictments. We don't issue arrest warrants. We determine whether or not reasonable suspicion that we have, our suspicions are reasonable, excuse me, that a felony's been committed. That's all we do. But what we gain from having done so is huge. I'm on page 3 of 19, malicious prosecution. If they bring a gross misdemeanor or misdemeanor false charge against you, it's a misdemeanor. But if they bring a false felony against you, it's a Class C felony. So if the felony charges are false, they've committed a Class C felony, they can be arrested. Criminal attempt. If a person attempts a Class A felony, they've committed a Class B. If they attempt a Class B, they've committed a Class C. On and on. 9A.40.040, unlawful imprisonment, like a false arrest, Class C felony. Listen how broad that is. A person is guilty of unlawful imprisonment if he or she knowingly restrains another person. Well, if you didn't have authority to restrain them, you've committed unlawful imprisonment. And that means sitting down in front of somebody's car so they can't go through the intersection. You've unlawfully restrained them. Class C felony. Page 4 of 19, residential burglary. If they maliciously procured the search warrant and went into my house and took stuff when the warrant was invalid and they knew it, they lied to get the warrant, or they didn't have one at all, how is it not residential burglary? Class B felony. And under that definition of harassment, I'm going to page 5. And I see theft in the first degree. And that's if the services or property exceeds $5,000 and is not a firearm or anything of any value that's taken directly from the person of another. So even if it's only worth 5 cents and I stole it from you, that is the felony count of a Class B felony. Theft in the first degree if I steal it from somebody that possesses it, or if I steal it out of their car and it exceeds $5,000. Okay? And then we have theft in the third degree, gross misdemeanor. Page 6 of 19, official misconduct. This is where the public servants live. It's the state analog of 18 U.S.C. 242, deprivation of rights under color of law. This is the state version of it. A public servant is guilty of official misconduct if, with intent to obtain a benefit or to deprive another person of a lawful right or privilege, he intentionally commits an unauthorized act under color of law, or intentionally refrains from performing a duty imposed upon him or her by law, with the intent to deprive somebody of a right or privilege. If a prosecutor fails to prosecute, they're not guilty because they're not depriving you of a right or privilege. They're simply failing to represent a case that the state or the government has against somebody. Criminal conspiracy. If they conspire to commit a Class A, they've committed a Class B. If they conspire to commit a Class B, they've committed a Class C, and so on. Page 7 of 19, kidnapping in the first degree. If they arrest you and they knew you were innocent, do they meet the definition of kidnapping? Trafficking in stolen property in the first degree. They impounded my automobile and had no right to do so, and prevented me from redeeming it out of impound and sold it at auction. How is that not trafficking in stolen property? You read the elements and then you look at the facts and you determine if the facts meet the elements of the offense. Leading organized crime. That's if somebody incites, leads, or organizes other people to go out and commit crime, as described there. Page 8 of 19, use of force when lawful. Clause number 2 is the Washington State Citizens Arrest provision, citizens arrest of a felon. The use, attempt, or offer to use force upon or toward the person of another is not unlawful in following cases. Number 2, whenever necessarily used by a person arresting one who has committed a felony and delivering him or her to competent authorities. Number 1 is the source of law enforcement's authority to make an arrest. So if number 2 is invalid, how come the police can still exploit number 1? There's federal case law that says number 1 is the source of law enforcement's authority to make an arrest, right in U.S. District Court in Seattle. Look at number 3. Force is lawful. Whenever used by a party about to be injured or by another lawfully aiding him or her. You're about to violate court rules. Suddenly, I think this says use of force is justified. Whenever used by a party about to be injured. Hey, you're writing me a ticket for failing to stop that stop sign. I got 3 other people in the car, and all of us say, I stopped. And you're writing a ticket when I'm not guilty? We have the right to use force against this person to prevent the injury. According to this, in a perfect world, and none of this is legal advice, but as an example of how many rights, the extent of our rights under the law is profound. In preventing or attempting to prevent an offense against his or her person, or a malicious trespass or other malicious interference with real or personal property lawfully within my possession. Bottom of the page, justifiable homicide. Homicide is also justifiable when committed either in the lawful defense of the slayer, meaning I was lawfully defending myself and I slayed this person, or his or her husband. I don't go along with that, so and you won't find Dave with a husband anytime soon. Wife, parent, child, brother, or sister. Thank you for staying after that one. When there's reasonable ground to apprehend a design on the part of the person slain, the corpse, to commit a felony or to do some great personal injury to the slayer or to any such person, and there is imminent danger of such design being accomplished. Or, number 2, the actual resistance of an attempt to commit a felony upon the slayer in his presence or in his residence. Next page, 9 of 19, intimidating a witness. A person is guilty of intimidating a witness if a person, by use of threat against a current or prospective witness, attempts to influence their testimony, tell him to elude the legal process, or to not avail himself to the proceedings. Page 10 of 19. Jury tampering. Como 4 News. The murderer was apprehended at his residence 2 hours after the body was discovered. When did Como 4's jury convene to determine that murder had been committed?
Now,
that's jury tampering. They're telling the whole jury pool it was murder. Murder is a point of law that's not established until the jury has considered the facts, heard the case, and has deliberated. But the TV will say the murder was committed last week when this guy. Murder is determined by the jury. and to inform the entire jury pool in advance. This is a murder. How is that not jury tampering when you read, a person is guilty of jury tampering if, with intent to influence a juror's vote, opinion, decision, or other official action in a case, he or she attempts to communicate directly or indirectly with the juror. That, I saw that repeatedly on local news. Seattle news is garbage. Perjury in the first degree, theft of a firearm. In Washington State, you want to study how you're required to carry your firearm, especially when you're driving. If you don't have a concealed weapons permit, it is to be unloaded and in plain sight. So I would carry it on the seat beside me. If they take my pistol saying, we're investigating for unlawful possession of a firearm or unlawful carry. What was on the seat sitting there the way the law says, that's theft of my firearm. You're in possession of a stolen firearm, you stole the firearm, it's a felony, Class B, I'm going to arrest you if you don't give that pistol back now. I got my pistol back with no questions asked. By telling the mayor, I'm going to arrest you for possession of a stolen firearm, page 11 of 19, top of the page, your cops took my pistol, it was on my seat, unloaded, in plain sight, and they took it anyway. You're in possession of a stolen firearm, I'm going to arrest you. And they gave the pistol back to me. With the clip out of the pistol was in a box with the slide action open and a zip tie around the trigger, around the barrel, so it couldn't function. It was in this little box tied to, hear ye. No questions, give him his pistol.
Well, what if you had it in a glove box? What would have happened?
Read the law. Like I said, read the law and find out. It's a crime.
Oh, wow.
You have to carry it in plain sight, like I said.
Oh, plain sight, okay.
Yeah. And definition of crime of violence, page 11 of 19. I'm going to page 12. Long definitions for that statute. I'm going to page 13 of 19. I'm still in the definitions under violent crime. Lots to know about that, okay? The panel's going to be asked to deliberate some complicated stuff from time to time. And this is the list of statutes I would first familiarize myself if I were going to sit on a citizens review panel. In this, what does and does not constitute a violent crime, it refers to a whole bunch of other crimes that you got to go look up and compare notes and study with other people on, compare notes among the group. And I don't know all that. Haven't had to. I'm not violent, and I've only been victimized a few times violently, so I'll count my blessings. 14 of 19, unlawful possession of firearms. There's the law right there that you want to read. Goes right through the next page. Unlawful possession of a firearm in a second degree, Class C felony. I'm going to page 16. Unlawful possession of a firearm continues. Page 17 of 19. Now I'm moving from Title 9 and 9A into Title 42. This first statute, 42-20-030, everybody said, oh, that's impersonation of a public official. Well, that's the first couple clauses. But it goes on to say, starting at the top, intrusion into and refusal to surrender public office. Every person who shall falsely personate or represent any public officer. Great, that's impersonation of a public official. Or who shall willfully intrude himself or herself into a public office to which he or she has not been duly elected or appointed. Or, and this is the one that I'm looking at specifically, who shall willfully exercise any of the functions or perform any of the duties of such officer without having duly qualified therefor as required by law. The law requires an oath of office. You don't have an oath of office. You're the mayor. You made a phone call to the police station saying, get your butt up here. Well, if that isn't an action performed by the mayor in the official capacity of the mayor, and you don't have an oath of office, this says you've just committed a gross misdemeanor. You're a police officer. You don't have an oath of office. You don't have the photo ID that the department has to issue you, and you put your butt in a patrol car. Gross misdemeanor. The law requires they have certain things, depending on the official, the officer, the agent, employee, whatever. And when they don't have that and they act within the office, gross misdemeanor. What this is the abolishment of de facto status. You can't operate as a de facto officer in Washington. It's a gross misdemeanor. So there's no such thing as de facto. You are either de jure, meaning you've satisfied everything to get that office, or you're a criminal. There's no such thing as a de facto officer in Washington. So there's a gold mine right there. False report, 42-20-040. Every public officer who shall knowingly make any false or misleading statement in any official report or statement, gross misdemeanor. If you prove that police report has a lie in it, excuse me, please bring your complaint to the panel. We're ready for this one. And our barrister, he'll line up all the facts of the case and present your case to the panel, and we, the people of the panel, will sign this complaint. I want you to go straight down to the prosecutor, and I want you to tell them to prosecute that cop. And then I want you to go to his boss and say, here's a criminal complaint, he lied in that police report, here's proof, here's witness testimony in writing, sworn statement. He's going to be prosecuted. You get him off the police force now. No guns, no M16, no mace, pepper spray, no patrol car for that guy. This is an easy one. There's barely a police report they don't lie on. Kirkland, Washington. 18 of 19, top of the list, public officer making false certificate. Every public officer who, being authorized by law to make or give a certificate or other writing, shall knowingly make and deliver as true such a certificate or writing containing any statement which he or she knows to be false. Gross misdemeanor. It's almost the same statute. False auditing or paying claims. Misappropriation and falsification of accounts by public officer. Page 19 of 19. 42-20-080. Other violations. Remember back to the prosecutor did not prosecute when they knew there's a crime being committed, but his failure to do so didn't deprive you of a right or privilege, so it's not official misconduct. But he still has the duty imposed upon him by law to prosecute. This is where I would go with him. 42-20-080. Other violations by officers. Every officer or other person mentioned in a certain RCW who shall willfully disobey any provision of law relating to his or her official conduct in cases other than those specified in such section shall be guilty of a gross misdemeanor. So if it's not a crime elsewhere, but it's still a duty imposed upon them by law, it's a gross misdemeanor for them to fail to perform the duty. Misappropriations by treasurer, and then 42-20-100, failure of duty by a public officer, a misdemeanor. Whenever any duty is enjoined by law upon any public officer or other person holding any public trust or employment, their willful neglect to perform such a duty shall be a misdemeanor. There's another one you can get the prosecutor on for failure to prosecute. Criminal complaint, bring it to the panel. So if the prosecutor is in the pipeline of all the prosecutions the panel hears, and he knows all of them, and he fails, every time he fails, it's a misdemeanor under this statute, unless he can provide evidence to the contrary. And the last one, improper conduct by certain justices. It shall be a misdemeanor for any judge or justice of any court, not of record, during the hearing of any cause or proceeding therein to address any person in his or her presence in unfit, unseemly, or improper language. So that's just my list of what I feel are the most commonly violated Washington state statutes. Plenty of them are felony statutes. You're going to be arrested. We got a panel. We're going to hear this criminal complaint. Everyone's going to know about it, officer. Your picture's going to be on the web. The license number, the patrol car you like to drive, your tax court, divorce court, docket numbers, you know, it's over for you. You really ought to just quit, leave to another jurisdiction so this doesn't amount to a big spot in your employment record, because we're going to your boss with this. Everyone's going to know, and we're going to make it a political nightmare for everybody that can terminate your employment contract. Leave now. Just leave now, peacefully, before they can fire you, because we're leaning on the prosecutor to prosecute it. If he doesn't, he's going to have another criminal complaint filed against him for misdemeanor. because he failed to prosecute. Citizens Review Panel.
Exciting.
Yes. So,
Power.
yes, our power.
Power of the law.
Common law rights, constitutional rights, criminal code, in the box, affirmative action, has nothing to do with anything other people are doing. This is just, I educate myself and I determine whether or not the facts add up to the essential elements of criminal statutes, and I'm learning and I'm learning. I learn from others that are on staff. I learn from attorneys that we might seek out that tell us how to assess when a crime has been committed. We might even go to the local universities, to their law schools, and see if we can get second or third year law students involved to stay totally in the box and to feed us information that they're learning in law school, so our job on the panel, we're more effective at our jobs, we're more responsible, and our work product therefore is more respectable, we retain credibility, and we have a tool to approach and affect change when we approach our public servants that have the most authority. The prosecutor, the judge, the city and county council, state attorney general, and we're going to keep the media in check by telling them, here's what you can and can't do. If you call a citizen's arrest a threat, we know you're involved in a conspiracy against our rights, that's a felony. We can arrest you. It doesn't have to be committed under color of law. 18 U.S.C. 242, if two or more persons conspire. 241, excuse me. If two or more persons conspire. 242 is deprivation of rights under color of law. That one the media cannot violate. It's not a felony anyway, who cares? But 242, they can violate. And so you keep that word threat behind your lips. It better never leave your mouth, because that's not what we're doing. And as soon as it does leave your mouth, it's obvious you and your boss are engaged in a conspiracy to deprive us of rights. We can arrest you. Why go there? Now that we all know our limitations, let's be friends. We'll keep you in the loop. This is all we're doing. We'll keep you in the loop. And so we'll even let you bring your cameras into our hearings eventually. You have our YouTube channel. You see what we do. If you want to take one in person and do a showcase on us on a news channel, great. We could use the press. And if it's bad press, you know, we've all made our decisions. I would encourage you to make it good press. You do what you do, we do what we do. So we're playing the game the way it's supposed to be played, in the box. And so there's nothing bad to say about this. Thanks for coming.